Shall I start?
Now give host permission to me again. Make me a host. Click to my user ID and make me host.
Right, sir, right.
Okay, okay, start. Thank you.
So, welcome all of you. My name is Archi. Today, I'm going to give a lecture, small on topic human rights in protecting forest resources. So, okay. So first, let us understand what are human rights. I think all of us are very much aware that these are basic rights which are needed for our full development, for our growth, and they are being inherent. Being inherent to us since our birth to death, and they are available to us without any based on discrimination on race, nationality, color, sex, religion, place of birth, language. They are available to us. So these human rights has been broadly being categorized into what is being right and having right. Being right is basically what is morally being taught to us, what is morally correct, what we follow is that we should study, we should follow this, we should follow religion, we should not follow. That depend on human nature, individual to individual, how one pursue. But having right is basically is more legally, that if one wants to study but not be able to study, then how they can fulfill this right, they can fulfill this this of education. So that is being more legally provided to us. So it's about having right legally. So when we talk about human right, there are also two, which is equality. So equality is mostly about the distribution of resources equally among different caste, creed, people of different nationality. Means distributing the resources equally. But equality, on the other hand, you see, it's about how we are providing some push or some upliftment to the one section of society which cannot, without the help, which cannot able to reach that resources. So there are ample of example in the daily life you see, and when you go through newspapers also, that government is bringing lots of policies for PPL class, for for students who are not able to reach at the higher study, who wants to reach, but maybe they do not have proper resources. So those sections which require push and which has been assisted through some help, then we say that is a equity. So these are some of the terms which I wanted to clear. Then what are the characteristics of human rights? These human rights are universal and egalitarian. Means they are it's not that you are in one country and when you go to other country, then your right to live and etc. has been taken away. So they are universal and egalitarian, is common to all. They cannot be waived or taken away. As I said that like fundamental rights in India, they cannot be taken away. Only they can be taken away when when there is an extreme condition, like we see when there is a situation on nation interest, then the right to speak and right to assemble, then some kind of restriction can be put or taken away based on the situations. Otherwise, these rights are being available all time to all individuals. As also you know that, okay, we will cover the fundamental rights later. Impose obligation upon state and state actor to respect, protect, and fulfill. So basically, these human right also place obligation on state so that states can protect our human right and give ample of opportunity so that we can live our life fully, and we can reach to whatever we want in our life. So there are some kind of obligation based on these states. They are legally protected. Some rights are available to us which does not require any law. But there in fundamental right also there are some kind of law which require a proper law on it. For example, like abolition of untouchability. On this, there is a proper law. Like this, there are been certain laws which require legal protection. Like this, the human rights are indivisible, interdependent, and interrelated. So we cannot say that one right is more important for a human being and other right is less important. So all rights are very interlinked and very interdependent on each other, and every right is very important to every individual. Now, there are two theories on human rights. First is natural law theory. Natural law theory and social utility theory. This natural law theory is talk about moral principle, or what we think about ethically, morally, that this is right, that this is not right, which does not require any legal law to tell us, okay, this we have to do, this we don't have to do. These are naturally and instinct. Uh, they are more basically like, for example, I have quoted, you will understand, like a parenting. For two people create a child, and parents are needed to for a child development. But this instinct does not require a law, like a legal law that only two parents will be needed. The court won't tell us that this is you have to do. These are natural based on our moral obligation, based on our what we inherit. So this all things comes under natural law theory. In social utility theory, as I told, in having right. Similarly, the social utility tell us that what the basic right are what we needed to express ourselves, to live life more confidently. For example, right to education. In right to education has been applied in a social utility theory, so that the students or the child who are living in BPL or in other section who does not have proper resources to say, so that they can be uplifted using these right, using these laws. So these what the state obligate us, these are the right which the state make, so that there should be a proper development of every individual, and which can culminately help in development of a country. Then human rights and international treaties. As you all know, before 90s, 40s, there has been lot of, there was a different scenario in not only in India, but around the world. The countries are more focused on ruling the other countries. The countries are basically they practice slavery, right? And there are a lot of genocides has been there, World War I, World War II. So once this all situation has been settled down after the World War II, the UN has decided to come with a document which is Universal Declaration of Human Rights in 1948, in order to make a peace in a world, and in order to protect the human rights and stop these all genocide. So they have come with this document, and this document is being currently available in 500 different languages, and currently it is having 30 articles. These article is non-binding on states which are the partner to this. Universal Declaration on Human Rights. But it also say that whenever the misconduct of any human right and all this thing occurs, so they reach to these codes. Okay, so like this, there has been lot of convention and treaties. You see that the Convention on Migrant Worker, Convention on Rights of Person with Disability. So there has been lot of concern regarding the human rights after the World War has been ended, and they give importance on like whatever the importance on human rights, their need, and one individual should live free and healthy. Similarly, human rights in India, they follow a lot of convention, such as the Convention on Migrant Worker. There are many reports come on migrant work, like the status of migrant worker in India, and the status of women and all those things. So India also follow a lot of international treaties uh, and also safeguard the human rights in India. In India, the broadly our human right has been protected under the Chapter 3, and it is from Article 14 to Article 32. As you all may be aware of these six important important fundamental rights in present in our country. These fundamental rights, we say it is negative also, and we say positive also. So according to the language of constitution, these what of negative fundamental rights? The negative fundamental rights are those rights which impose duty on state, that they have to do some exercise or do bring out some laws so that they can create opportunities for people who are not being, as I said, not being able to achieve those resources without the help of the state, such as right to equality, like right to or equal opportunity. We see in Article 15, right for equal opportunity. For equal opportunity, they need to uplift the society, the BPL society, or any other section of the section in our Indian states. So they have to uplift them. So for them, the state has to do some exercise so that they can get to up to that level, so that where they can compete with the other people also. So similarly, a positive nature of fundamental right is that the person or an individual enjoy in India without that these rights, those rights which cannot be taken away by Indian state in any situations. Also, the one of the interesting things we get in India in fundamental right is that some rights are exclusively for Indian citizens, and rest of the apart from them, some rights are for both foreigners and Indians. If you want to know that like what are the rights, you can just I will tell you one, two, like Article 15, Article 16, Article 21. These are few rights which are exclusively for Indian citizens. Now we will talk about human rights and the role of NGO. As I said, that the government is doing their duty, and they have made laws, they have made fundamental rights. But what is the role of NGO? NGO are they have been defined under Economic and Social Council of United Nations. They say they are any international organization which is not established by intergovernmental agreements, and they have been mentioned under United Nations Charters Article 71. They have been recognized by this. So NGO has been, you have been aware, maybe nearby you, there has been a lot of locally NGO. So what is the main role is that they do the ground exercise. A government can make laws, government can bring out with the strict laws, but there has been some agency which has to do groundwork. Like a government can make a law that there should be no child marriage, no marriage below 21. But maybe there are situations which is happening like locally, a person is not able to speak. So these NGO motivate people to express themselves, to bring the atrocities to them, like what is happening, and the role of NGO is most importantly is to keep a check on government, like what exercise they are doing. Are they correctly following the laws? Are they correctly delivering the justice? So NGO is a link between people who is living at the ground and those who are doing their exercise at the top level. So they keep a check on both. So now human right and the environment protection. So there is a close relationship between human right and environment protection. Safe and educate environment is one of the means by which human right can be protected and promoted. So in India, we have Article 21, uh, which talk about, yes, we have Article 21, which talk about that no person shall be deprived of his life and personal liberty. So Supreme Court say that in the personal liberty, they also have this part of living a healthy life in a clean environment. So our Supreme Court will say that we have a right to live in a clean environment. So as you see in European Court of Human Rights, there has been around 300 environment related cases. In India also, we now have a particular institution which is called the NGT, National Green Tribunal, which take the cases of any environment related cases, which I will give an example later. But before that, there is a very popular example of this environment case, and this the role of NGO and the PIL and the voice of people is about the Narmada Bachao Andolan. You must all have read about it. So it all started in 1985 when Jawaharlal Nehru, our Prime Minister, has has given an order that we will create a few dams that may be around 3,000 of large and consisting of small dams. These will be constructed on Narmada River. The major goal was so that the large amount of water which is falling in the Arabian Sea, so that they can decrease that and provide water to nearby villages and to the livelihood. But uh, but every development come with the cost. So the cost was huge. Cost was not financially, but the cost was about the relocation of the people. It has been said that the 11 million people has to be relocated, but the project was like so much used. It got international attention. The World Bank has invested in this project about too much of crore, which I don't remember the exact amount, but you can see that there will be a lot of clearance. There will be a lot of shifting of people from their land to other areas. So it has caught the attention of Medha Patkar and the other locally NGO, which then they have in 1985 they have organized a movement and they have bring this attention to the national level, that it got stopped between 1994 to 1999. The project got stopped, and it was the first time that this scenario got the national attention, also the international attention about the cost of relocating the people from their natural, from their original places, the cost of the environment damage, all this got a huge attention. And one of the reason is also that the NGT came later. And I will give an example of NGT also, but you can, now I have given an example of how a one movement can create a national attention, and how what will be the later results. So when we talk about our fundamental rights or our human right, if they get violated, how we going to like reach, and how we can seek remedies. So basically Article 32 and Article 226, it talk about, Article 32 talk about that we can reach to Supreme Court using the writs. I will not go too much detail in constitutional, but using the Article 32, we can, when our fundamental rights has been violated, and which involve the constitutional attention, then we can reach the Supreme Court. And in Article 226, we can, using the Article 226, we can reach to the High Court. Similarly, using the public interest litigation, it is a method where a large cross-section of people have a similar interest or a similar points that they have to make it to the court, or need a public attention. I don't know it is right to say or not. For example, we can say Sabarmala case, temple case. What happened is the case of like gender discrimination. Okay, so it was an attention of the large public. They have been put into PIL, and from there they can put it into like High Court and Supreme Court. And the other means how we can help people to learn about their human right is about through education. It's about the public awareness, making them aware that what right they have, especially when we talk about the lower section or the people from backward areas. They have no outreach that what right they have, what actually the policies for them, what are the policies they can enroll in them, so that they can get benefit, financial benefit, educational benefit. They don't have right. So from public awareness, we can definitely reach out to them. Also, there has been in India many commissions, statutory bodies have been made. Such one of the example is National Human Rights Commission. Other are the National Commission on Minorities, National Commission for Women. Similarly, there has been a lot of attention, public attention. Recently, there has been National Commission for other backward class. Earlier, it was under minorities, but it has separately got a statutory status. It has made a separate chapter in the Constitution. For when I come to NGT, NGT got its attention in 1972, and in 90s we have adopted this NGT. So one of the case I would like to bring is Samir Mehta versus Union of India. So this was a case when a ship was carrying huge ton of coal, petrol, diesel, and etc. kinds of fuels. But that ship, due to the technical clutch, it got a spillover, and it got like spillover. You understand that it has covered a huge area where it has disturbed the environment, ecosystem of marine, and also caused devastated for livelihood for fishermen. So what happened? This case was then. This was actually the Andani case, Andani industry. So the Andani industry has done nothing to like mitigate or to take action how to control the spillovers. So Indian Coast Guards has been has been doing the the precautionary work. Sorry, after like curing work. So what happened? It has created a huge amount, invested a huge amount in correcting these spillovers and protecting the livelihood of fishermen. So one environmentalist and activist has put a case. Samir Mehta, his name was Samir Mehta. He put his case in NGT and got national level of attention. So due to this, the entity has gone with a various study of the cases, and finally the Adani group was held as uh, this as a like a proper. Sorry, I'm not able to get that word. So the entity has made a charge of 100 crore on Adani Group for giving on correcting the livelihood of people and also the cost of ecosystem damage they have created. So there has been lot of pollution cost, water pollution cases has been under NGT, which has been in news day to day life, but only few get the right justice. So it is depend on what it is depend on how we aware that we can take action, we can take a stand on this, and the role of NGO is very important, that they being activist in these parts. If the NGO does not do the correct work, then how these laws which has been made, how it can be properly implemented, how they can justify their work. So with this, I come to end of my lecture. For thank you, and for if you have any questions, you can just ask me.